Merci beaucoup. I'm going to break the rhythm of the presentations so far by making my presentation in English. But it's a great pleasure to be here, and I congratulate the organizers on the very impressive program they have been able to put together. I've been asked to talk about the interaction between the law of the WTO and public international law, and the continuing relevance of public international law to international trade law. And in some respects, it's a very strange topic. Would there be a paper at a conference on the law of the sea, on the relationship between the law of the sea and public international law? Would there be a paper at a conference on international human rights, on the relationship between international human rights law and public international law? In both instances, the idea is somewhat bizarre. The law of the sea is public international law. International human rights law is public international law. But it doesn't seem strange to talk about the relationship between international trade law, or WTO law, and public international law. Why is this so? And I would suggest that the reason is partly historical. The historical legacy continues. And the reason also is partly the tyranny of the disciplines that also continues. Public international lawyers have often not been trained in international trade law or WTO law, and international trade lawyers often do not start with a background in public international law. And let me make a brief comment about the history. GATT was always referred to as a contract, not a treaty. And the reason for this was that if it had been characterized as a treaty, it would have to be ratified by the US Senate, and that was not going to happen. GATT was a provisional means for securing tariff concessions and implemented in a way that did not require Senate ratification. And of course, the language used and the way it was spoken about, GATT was binding, but notwithstanding the language used and the way it was spoken about, GATT was binding, and contracting parties acted as if it was binding. To use the language of the definition of a treaty in Article 1A of the Vienna Convention on the Law of Treaties, it was an international agreement concluded between states in written form and governed by international law. Tariff bindings were binding. They weren't optional. But much of this was obscured because of the way in which GATT functioned. The representatives of the contracting parties attending meetings of GATT talked about it as a contract, not a treaty, and they were generally not lawyers. They may well have believed that the contract was different from a treaty. And it was not until, at least in English, John Jackson wrote his treatise on the law of GATT that lawyers started to turn their attention to this economic arrangement. And the view that GATT was somehow different was reinforced by the dispute settlement process, which in its earlier days looked more like a conciliation or mediation process than adjudication. And the language of dispute settlement, nullification and impairment, rather than breach, a recommendation that the GATT Council require the offending party to withdraw the measure, was not language of adjudication. And all of this was going on outside the frame of reference of public international lawyers. Textbooks on international law made no reference or little reference to GATT, and international legal scholars did not study the field generally. That's not true. There were some prominent public international lawyers who looked at GATT and international trade law, but they were the exception. International trade law was the domain of domestic lawyers who dealt with customs matters, imports and exports, anti-dumping, subsidies, and safeguards. GATT might have been part of a course on international business transactions, sometimes referred to as international trade law, but it was rarely a course in its own right as a course on public international law. And when domestic law, it tended to go one way, in fact, once public international law and international trade law was seen to collide. When domestic lawyers dealing with trade remedies started to become interested in GATT, they started to become familiar in a rudimentary way with elements of public international law. But it really did not go the other way. And of course, all this changed with the advent of the WTO. Perhaps most importantly, the language surrounding the new agreements changed. Now there was talk about law. No one could make the mistake of thinking that the agreement establishing the WTO was just a contract. It was a treaty, and although the WTO system has its distinctive elements, the WTO is an international organization, just like other international organizations, the United Nations, specialized agencies, and so on. And of course, the DSU included the famous Article 3.2 under which the WTO agreements were to be interpreted in accordance with the customary rules of interpretation of public international law. No clearer indication could be found that the framers of the agreement saw the agreements as being public international law, or perhaps they did not anticipate how far this would go. Public international lawyers, I think, though, were still confused by the language. The non-legal sounding language of GATT that continued: panels, recommendations by dispute settlement bodies, not decisions or award, new language of appellate body and dispute settlement, understanding. Still today, I think, to some public international lawyers seem impenetrable. They often talk about decisions of the DSB when they mean appellate body reports. And the reaction of this to all of this has not been surprising. We have the view sometimes expressed that while DSU Article 3.2 incorporates certain rules of public international law, that does not mean that rules of international law that do not relate to treaty interpretation are applicable. The first members of the appellate body, perhaps in order to dispel this popular impression of the relationship between WTO and public international law, went out of their way to refer to and incorporate principles of public international law, although not always obviously. It might be useful just to sketch out how in principle public international law is relevant to the regime established under the WTO agreements. The starting point, of course, is that this regime established, regardless of the different or peculiar terminology, is treaty-based. The single undertaking is nothing more than a collection of agreements, all contained within a common framework. And they're part of a comprehensive treaty arrangement, whether they're called understandings or not. And as treaty instruments, they're to be interpreted in accordance with the rules of international law relating to treaty interpretation. And on that basis, the interpretation provision in Article 3.2 of the DSU is simply superfluous. Even if it were not there, the rules of treaty interpretation would still apply to the interpretation of WTO agreements. And if one asks, well, to what extent are rules of public international law other than rules relating to interpretation relevant to the WTO agreements, then that question is also a question of public international law, because it's a question that's applicable to all treaties, their relationship to principles of customary international law, or general principles of law, or what is called, sometimes referred to as general international law. And I think this was understood very clearly by the panel in Korea Measures Affecting Government Procurement, where it said, customary international law applies generally to the economic relations between WTO members. Such international law applies to the extent that the WTO agreements do not contract out of them. To put it another way, to the extent that there's no conflict or inconsistency, or an expression in a covered WTO agreement that implies differently, we are of the view that customary rules of international law apply to the WTO treaties and to the process of treaty formation under the WTO. And in fact, the interrelationship between what are referred to as rules of public international law and WTO jurisprudence is very widespread. In a recent book published, written by Graham Cook, where he puts together a digest of WTO jurisprudence relating to principles of the application of principles of public international law and concepts of public international law, he cites over 200 panel or appellate body reports or arbitrators' awards where public international law rules or principles are discussed. And of course, none of this comes from the volition of panels or the appellate body. They're discussed because they're raised by the parties, by WTO members. So WTO members clearly regard international law as relevant to the interpretation of the WTO agreements. Now, this substantial invocation of public international law raises questions about the correctness of the use of public international law concepts, principles by the WTO dispute settlement organs. It's widely understood that WTO panel members are not generally drawn from a community of public international lawyers. They're primarily government or trade officials who may be lawyers and may have had some training in public international law. And while there have been members of the appellate body who are distinguished in international law, many members of the appellate body do not come from an international law background at all. And I think lack of familiarity with the terminology of international law sometimes shows in the reports. For example, the term general principles of law, a term embodied in Article 38(1)(c) of the statute of the ICJ, is sometimes rendered as general principles of law, of international law, a term that has a somewhat different meaning. That difference did not escape the biotech panel, however, which made it clear that its reference to general principles of international law encompassed both customary international law and general principles of law. There's also been some confusion over the role that rules of international law can play. In the US anti-dumping duties, the appellate body pointed out that the panel was incorrect in considering whether rules on state responsibility could be applied in order to replace the ordinary meaning of the terms of the SCM agreement. Rather, it's the WTO agreement, the SCM agreement, that has to be applied. The rules of state responsibility are simply taken into account in interpreting the rules of that agreement. Now, the areas of public international law that have been referred to in WTO jurisprudence are diverse, but two areas have seen particular attention, that relating to the rules of public international law in the interpretation of the agreements, that is, I mean Article 38(1)(c) of the Vienna Convention on the Law of Treaties, which refers to other rules of international law applicable between the parties, and it was referred to this morning by Gabriel Marceau. And the other area, which was referred to, in fact, by Judge Sacerdote at lunchtime, the use of subsequent agreements and subsequent practice in the interpretation of the WTO agreements. Now, Article 38(3)(c) is interesting because of its history. The ILC Special Rapporteur on the Law of Treaties, Humphrey Waldock, had proposed a rule that referred to rules in force at the time the treaty was, the treaty's conclusion. In other words, originally 38(3)(c) related to contemporaneity or intertemporal law. But that view was rejected by the members of the Commission, who wanted the reference to cover both rules in existence at the time the treaty was concluded and rules that came into existence after the treaty was concluded, or rules applicable at the time the treaty was interpreted. So Article 38(3)(c) has a more open-textured nature. Now, I'm not going to deal with that in great detail. Of course, the standard case in which indirectly, in a sense, Article 38(3)(c) is elaborated is the Shrimp Turtle decision, where, without citing Article 38(3)(c), the appellate body referred to rules of international law, some treaty-based, some not treaty-based, including a resolution of a conference, in order to help interpret the term exhaustible natural resources. And it took these into account, it seems, not because it regarded them as rules binding on the parties, but rather to show, and I quote, the recent acknowledgement by the international community of the importance of concerted bilateral and multilateral action to protect living resources. In other words, the appellate body was influenced in terms of the international context demonstrated by agreements, resolutions, and acts of states in order to understand the meaning of Article 20G of the GATT. It did refer to Article 38(1)(c) in a footnote when it was looking at the chapeau. And again, its statement was, the appellate body footnoted it to a statement about, I'll quote it, "Our task here is to interpret the language of the chapeau, seeking additional interpretive guidance as appropriate from the general principles of international law." In other words, it equated the statement about other rules of international law applicable between the parties to be the same as general principles of international law. One could argue that they're actually not the same, and in fact, rules of international law were deliberately used in the Vienna Conference to reject the term principles, or at least in the International Law Commission to reject the term principles. But in any event, the appellate body gave a fairly expansive approach to the way in which one can have reference to international law. Now, in the interest of time, I won't continue with that particular point, except to say that the appellate body's decision in Shrimp is actually probably at the forefront of public international law in looking at the way in which other rules of international law should be taken into account. We don't think about it that way, and again, Giorgio Sassanotti made the point earlier on, because the International Court of Justice historically has not looked at the WTO as being a source of international law. Let me look at another area where I think one can argue that, unlike the shrimp and the Article 38.3c, one might argue that a question can be raised about the appellate body's use of principles of international law. And I refer here to the use of subsequent agreements within the meaning of Article 31.3a, and I'll focus on the decision in the clove cigarettes case. Now, that case involved an interpretation of a particular provision of the rather technical rules of the TBT agreement. In this case, Article 212, the requirement that there be a reasonable interval between the publication of technical regulations and their entry into force. The appellate body was faced with the decision of the ministerial conference on the meaning of reasonable interval. It treated the ministerial decision as a subsequent agreement of the parties on the interpretation of that particular provision and gave effect to it. And the analysis of subsequent agreements is actually quite good at that point of the appellate body's decision. But the situation is more complicated, because Article 9.2 of the WTO agreement gives exclusive authority to the ministerial conference and the General Council to adopt interpretation of the WTO agreement and the MTAs, and it provides a procedure for it to be done. There has to be a recommendation from the relevant council, and the interpretation must be adopted by a 3/4 majority. And the appellate body concluded that the ministerial decision was not taken on the basis of a recommendation of the relevant council, and therefore could not be regarded as interpretation by the ministerial conference within the meaning of Article 9.2. Nevertheless, the appellate body went on to apply the interpretation on the basis that the ministerial decision was a subsequent agreement within the meaning of Article 31.3a. In short, the appellate body bypassed the requirements of Article 2 as a means of a subsequent agreement, or to put it another way, Article 31.3a trumped Article 9.2 of the WTO agreement. Now, it's not clear whether the appellate body fully considered the conflict between the provisions. It noted that it had authority to apply the principle in Article 31.3a and said that the interpretation rule under Article 9.2 of the WTO agreement and the subsequent agreement principle under the Vienna Convention serve different functions and have different legal effects. Well, that's true, but if you look at what was done, the appellate body seems to take in the view that if the ministerial decision constituted a subsequent agreement, then it was to be applied. But this ignores, I think, what Article 31.3 really says. Subsequent agreements are not definitive for the purpose of treaty interpretation. They're just to be taken into account together with the context. In other words, it's a consideration whose weight depends upon the context. And that means the other elements of Article 31. And the context for the interpretation of Article 212 of the TBT agreement must include the WTO agreement itself. And surely a relevant factor to be taken into account in the ministerial decision as an interpretation of Article 212 of the TBT agreement is that it did not comply with the requirements of Article 9.2 for subsequent agreement, or for interpretation of the WTO agreements. So its weight as a subsequent agreement must have been seriously impaired because, as a subsequent agreement, it ran counter to what was provided in the WTO agreement. It's difficult to see how the Article 9.2 rule can be regarded as completely separate and autonomous from Article 31.3a. Interpretation, in fact, what they did was to say that an interpretation that did not meet the requirements of Article 9.2 had exactly the same effect as an interpretation that did meet those requirements. In other words, it governed the interpretation of the 2.12 of the TBT agreement. Let me just finally, because I've got the 1 minute card, you can't see it, but I can, in front of me.
If you needed 2 more.
Well, what I'll do is, rather than continuing on the point about Article 31(3)(a), let me just draw some conclusions, very tentative conclusions. First of all, I think we have to stop talking about the relationship of public international law and international trade law, and so perhaps I'll never be invited again to a conference to talk about that subject. International trade law is embodied in international law. The issues are simply the relationship between treaties and customary international law, the relevance of general principles of law to the interpretation of treaties and other international legal principles. Secondly, the work of the appellate body in dealing with public international law needs to be studied, and that of panels too, needs to be studied much more closely. In the paper that will eventually emerge, I'll deal more in detail with Article 31(3)(c, and I've dealt with Article 31(3)(a. But there's a substantial jurisprudence, and if you look at Graham Cook's digest, you see there's a substantial jurisprudence of the appellate body and panels dealing with public international law. And I think there's a basis here not just for a contribution to WTO law, but for a wider understanding of what's being decided as a contribution to international law more generally. And also I think what emerges from this, and particularly from the, one should turn off one's sound before using your computer. One should, once when I was doing this, I had Skype on and my daughter tried to phone me, which is not the best thing to happen. And I think that the 31(3)(a) subsequent agreement issue shows there's an increasing interaction between the actions of WTO organs and dispute settlement. And I think one can draw a parallel between the early United Nations era, when the Charter of the United Nations is being interpreted in the light of the practice of the organs of the United Nations. Some important decisions of the International Court of Justice interpreted the UN Charter on the basis of that action. And I think we're at the same time, in fact, now with the development of the WTO, where the WTO agreements are going to be interpreted more and more in the light of practice of the organs and practice of public international law generally. And then I would suggest, and I think that's probably my third or fourth point, that we need a better understanding of public international law by international trade lawyers. International law is not something simply to pick up and apply when it seems relevant, because I think you can fall into errors, and I would suggest with respect that the appellate body did in terms of the closed cigarettes case. It didn't look at the matter fully. It looked at what seemed an obvious solution, which it had already used, I think, in the tuna case of the subsequent agreement, but it was more complicated. And so I think that we need a greater understanding of public international law. I think that means that education in international trade law has to start with education in public international law. And just to open up another area in which I know Joost is very interested, it also raises questions about the appointment of WTO panel members. Are they being appointed from a group? If they're looking at public international law so often, are they being appointed from a group of individuals who can be expected to understand and apply public international law?